India.com 35 www.insightsays.com Q5 The torture of individuals in state custody remains a brazen human rights abuse that mocks our governance even as we claim human dignity as the end objective of the Indian state. Why torture is a cause for concern and what should be India's stand on this issue? Comment. 250 words. The Hindu torture is concerned in India. India's NHRC had reported a significant number of torture cases involving police and security organizations. It has been urging the government to recognize torture as a separate crime and codify punishment in a separate penal law. Judicial stand in Ravi Singh v. State of Haryana 1980 and Sheikhalad Abdul Gabbar Khan v. Vasant Raghunathan 2003. The Supreme Court said it was deeply disturbed by the diabolical recurrence of police torture is visible and torture is assuming alarming proportions. Forcible feeding, sleep deprivation, sound bombardment, electric shocks, cigarette burning, and other forms are forms of torture used by government agencies in India. Failure of India to ratify unconvention despite citing its difficulties in extraditing criminals from foreign countries are presented to the absence of a law preventing harsh treatment by authorities. Neither the Indian Penal Code nor the Code of Criminal Procedure specifically or comprehensively addresses custodial torture. Unlike custodial deaths, the police are not required to report cases of torture which do not result in deaths to the NHRC. The Supreme Court guarantees that citizens could claim against the police the right against torture and declared that it flows from Article 21's guarantee of personal liberty. Torture increases the hatred towards the state machinery and it does not give an opportunity to the perpetuator to reform. What should India's stand be? India needs to expeditiously ratify the Convention Against Torture. The government needs to pass the Prevention of Torture Bill 2017. The draft Prevention of Torture Bill 2017 proposed stringent punishment to perpetrators to curb the menace of torture and to have a deterrent effect on acts of torture. The punishment could extend up to life imprisonment and include a fine. An effective mechanism must be put in place to protect victims of torture, complainants and witnesses against possible threats, violence or ill treatment. The state should own the responsibility for injuries caused by its agents on citizens, and the principle of sovereign immunity cannot override the rights assured by the Constitution. Police reforms, including community policing, need to be further encouraged. More powers should be given to human rights commissions in India to do suo motu proceedings against the machinery responsible. Judiciary reforms are needed so that under trials do not spend much time in prisons. Q6 The reconsideration of the flaw verdict in Suresh Kumar Kushal will not only complement Justice K.S. Puttaswamy v. Union of India judgment, it will also give hope to aspirations of progressive India. Comment. 150 words. The Hindu background. In the Kushal judgment in 2013, the Supreme Court upheld the validity of Section 377 of the Indian Penal Code, which criminalizes gay sex. The reconsideration of the flaw verdict in Suresh Kumar Kushal is now in prospect. www.insightsanindia.com 36 www.insightsays.com With a curative petition in SC, there is fresh hope that the Delhi High Court judgment of 2009, which read down Section 377 to decriminalize consensual sex between adults, may be restored. Reconsideration of Kushal judgment is needed. Supreme Court judges observed in Justice K.S. Puttaswamy v. Union of India that equality demands that the sexual orientation of each individual in society must be protected on an even platform. The right to privacy and the protection of sexual orientation lie at the core of the fundamental rights guaranteed by Articles 14, 15 and 21 of the Constitution. Ever the National Legal Services Authority v. Union of India 2014 regarding the rights of transgender persons questioned the crucial reasoning. There has been a body of jurisprudence that sees gender identity and sexual orientation as an aspect of privacy, personal freedom and dignity. The Kushal judgment exhibited a total disconnect with the expanding horizon of human rights. The Universal Declaration of Human Rights states that all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. The Kushal judgment diminished the high standing of Indian human rights jurisprudence. It exhibited a total disconnect with the expanding horizon of human rights. In a crucial judgment, LGBTQ people are treated as unapprehended felons is a great blow to the doctrine of equality, privacy, and dignity embodied in liberal judgments of Supreme Court. The crucial judgment is also called out for relegating its constitutional responsibility with the claim that LGBT persons constitute a minuscule fraction of the population. This articulation of privacy as personal autonomy is also what might be used in dealing with the vast number of medical professionals across the country who insist on treating homosexuality as a disease, in many instances detaining queer persons in clinics and administering treatment against their will. Conclusion: the recognition that privacy is linked to autonomy and the navigation of space should allow people to think about the ways in which public spaces can be made safer for people who bear physical markers of gender nonconformity, whether it is public transport or an establishment space. With the right to privacy judgment, it is not